I call this meeting to order. Welcome to meeting number 63 of the House of Commons Standing Committee on Citizenship and Immigration. Today, pursuant to the order of reference of Wednesday, November 16, 2022, the committee will resume consideration of Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. I want to thank the officials who are here today. We are joined by Nicole Gerard, Director General Citizenship Policy, Yuan Huang, Senior Director Legislation and Program Policy, Erica Shenderit, Counsel Legal Services, Alison Bernard, Senior Policy Analyst, and also Judy Devan, Senior Analyst. Thank you all. Thank you for providing us the support as we go through clause by clause on this. We are continuing our clause by clause study of the bill. When we left, we were on clause 1. NDP 2 was just voted on and was defeated. A reminder that since NDP 2 has been defeated, amendments NDP 7, NDP 10, NDP 11, and NDP 13 cannot be moved since they refer to paragraph 3(1)(s) that would have been created by NDP 2. So we will begin with NDP 3. Ms. Kwan, would you like to move it?
Thank you very much, Madam Chair. I will therefore move NDP 3. And this amendment is really related to the package on second-generation cutoff rule, and it extends the extends citizenship to second-generation born abroad in subsequent generations, and restores those impacted since the second-generation cutoff rule was enacted back in 2009. And included in this, I should just point out that it also recognizes the connections test for it to apply for both the parents and the grandparents.
Thank you. Ms. Kayabaga.
Thank you, Madam Chair. I'd like to propose some amendments to sub-amendments to NDP 3. So I'd like to move that NDP 3 proposing to amend Clause 1 of Bill S-245 by adding text after line 14 on page 1 be amended by A, substituting the following for the words G and H of the proposed paragraph 3(3)(a), open marks, G, and then G.1 and H. B, substituting the following for the words GH in the proposed subparagraph 3(3)(a).01I. Those 2 points open again, G.1H. If the person, and B, sorry, that was A, B, if the person was born before April 17, 2009, and at any time, only one of the person's parents was a citizen and that the parent was a citizen under any of the following provisions, or both of the person's parents were citizens under any of the following provisions. So 2.3, subsection 3(3) of the Act is amended by striking out or at the end of the paragraph A.2 by adding or at the end of the paragraph B and by adding the following after paragraph B. Oh, sorry.
Ms. Kayabaga?
No, I'm not done, Madam Chair. Just give me a second. I'm missing page 2.
Then we will come.
I'm not done. Thank you, Madam Chair. Sorry. Right. So, going back to the first
Juste point d'ordre, Madame la Présidente.
A point of order, Madam Chair. I don't think that we have the French version, at least the interpreters do not have the version. I don't have it on paper, so it's hard for the interpreters as well to follow what's being said, and I don't have the sub-amendments in paper format in French. Can we please have them?
Ms. Kayabaga, do you have them in both official languages? Or?
ask for just NDP 3.
Madam Chair, for the NDP 3, the amendment the first amendment that I'm making is a really small amendment.
Okay, do you have them in both languages?
Yeah, we do.
Okay, before we go further, I will ask, I will suspend the meeting for 2 minutes so that the clerk can get that in French to Mr. Brunel Desap, and then we can come to you, Ms. Kayabag. Kayabaga has the floor. She is proposing some amendments to NDP 3. Ms. Kayabaga.
Thank you, Madam Chair. And just for the sake of not being super confusing to everyone, I'm going to take one amendment at a time and then put them on the floor one at a time. So I'll go back to the first one that I was proposing. I would like to move that NDP 3 proposing to amend Clause 1 of Bill S-245 by adding text after line 14 on page 1 be amended by A, substituting the following for the words GH of the proposed paragraph, 33A, G.1H, and B, substituting the following for the words GH, the proposed subparagraph 33A.01I, G.1H. And this is a minor change. Madam Chair, the bill gives citizenship to all those impacted by the former Section 8. And these individuals will now be represented in the Act under subsection 3.1 as paragraph G.1. So we needed to add the G.1 to NDP 3 in 2 places to add them on the list of the people that can't automatically pass citizenship to children born abroad without substantial connection. Thank you, Madam Chair.
An amendment proposed by Ms. Kayabaga on NDP 3. So we have amendment on the floor. Mr. Reddycock.
So just so that I understand, and I'll attempt to read it back to you. So basically you're saying that this adds a new section because of what we did before, and it prevents somebody from passing on citizenship to a new class of person. Is that what you said?
it has reference to
Sorry,
the.
I should ask them, but go ahead.
So go ahead.
Sorry, guys, I forgot you were there.
Yes, it's further to the remedy that the committee voted to agree to in the last session to add those Section 8s as citizens, but creating a new category for them, G.1, and at the same time saying that their descendants, confirming in the scheme of the Act that their descendants are subject to the first generation limit. So there's no transmission unless the family member is meeting the connection test that's under discussion.
Thank you. Seeing no further discussion, Mr. Kimmich.
Again, because this is so complex and it involves so many subparts of the Citizenship Act now. So far, with the amendments that have been accepted, with this sub-amendment to NDP 3 amendment, this means that the 1095 rule will apply to people who are seeking the right, not the grant of citizenship. If one of their parents is a Canadian citizen, in those cases, correct?
That's correct. For those who are remedied in that, the descendants of those remedied in that narrow category of Section 8s. So it's a minor amendment to ensure that the descendants of those who are remedied in that category will be subject to the first generation limit, and also can access this. There's no pathway to citizenship for the descendants unless the connection test is met. The 1095 days. The member is correct.
This just makes it more consistent than with other parts of the Act. And the only this is the substantive connection test, the 1095, correct? That's the only requirement that
Yes.
will be required.
It's consistent. The member is correct.
Rampal Gardner.
So, and just to clarify, in no part, in no amendments that we've made yet, there's no obligation for consecutive, I guess, residency or time in Canada, correct?
That's correct.
Okay, and that's consistent with other usages of the rule in other parts of the Act as well, too?
Yes, I believe that's correct.
Okay, and just to be clear, what I'm asking is, anytime that there is a presence test that is required in other parts of the Act, there's no obligation for the time to be consecutive. Is that correct?
Yes, that's correct in the sense that for a grant of citizenship, the current requirement is to accumulate 3 years of physical presence at any time within the qualifying window of 5 years. So there's no requirement for it to be consecutive. That's correct.
Okay, and sorry, Chair, thank you. And so, based on the amendment that was just made, is it clear that it still has to be within the 5-year window, or is that not clear now with these amendments?
Ms. Girard.
Yes, thank you, Madam Chair. This is the 5-year window doesn't apply to this cohort because in this case we're talking about the descendants of citizens for whom the connection test on the family member is as 3 years of physical presence. So it's a slightly lower threshold, if I can put it that way, because there's not a specific window.
Ms. Rampal Gardner.
Does the department have any concerns about there sort of being a discrepancy between other parts of the Act, like in terms of window and the provisions that we're building here? Like, is that going to create a legislative dissonance, if you will? Or are there any concerns with that?
Ms. Girard.
Thank you, Madam Chair. I'm not aware that any concerns have been identified at this point in time. Thank you.
Thank you.
Mr. Kimmich.
Thank you, Chair. I just remembered on Monday, one of the questions we asked is how many people would this change affect? In this particular section, with this amendment and then sub-amendment, do you have those numbers? And then do you have the numbers from Monday to those questions about how many lost Canadians would be encompassed by the amendments passed so far in this committee?
Ms. Girard.
Thank you, Madam Chair. As I mentioned on Monday, depending on which legislative remedy, in terms of which aspect of the bill is under discussion. The department doesn't have a specific estimate or a way to have a precise number. Those remedied by Section 8 are a relatively modest cohort, I think, as we've discussed before. We see in the order of 20 to 30 such cases come forward every year. Those who could benefit from the second generation connection test could potentially be in the thousands, I think, as we discussed at the previous session, although it really depends how many come forward to the department to request a proof of their citizenship, and there's no way to know that in advance. I think that's covering your question, but my apologies if I left a part out. I'll be happy to cover it.
Thank you. Mr. Kimmich?
Actually, the 2030, it kind of gives me an idea of, and potentially thousands. If this sub-amendment passes, just so I'm perfectly clear, this is by right, not by grant citizenships, correct? Like this section G1, G and H and G.1, this is by right citizenship.
That's correct.
To apply the same rule.
That's correct. Though this sub-amendment is targeting the descendants of the narrow cohort. And so one would anticipate that those numbers are likely to be more modest, though it's difficult to know in what range they may be.
Mr. Done? Ms. Lalonde?
Thank you, Madam Chair. So just for our officials, so in regard to this sub-amendment, if I may ask, my understanding is all this does is to take the former Section 8 people that were added with the amendment of G3 that we passed and make sure that they are added in the listing of folks in the NDP3. And could I ask, is that correct?
Yes, that's correct. Thank you.
Ms. Lalonde? Okay. Seeing no further discussion, we will take the vote on the amendment proposed by Ms. Kayabaga. Mr. Clerk, if you can take the vote.
Mr. Ali?
Yes.
Mr. Dhaliwal?
Support.
Monsieur El Khoury? Madame Kayabaga?
Pour.
Madame Lalonde?
Oui.
Mr. Kimmich?
For.
Mr. McGuire?
For.
Mr. Redekop?
Yes.
Ms. Rampel-Garner?
Yes.
Monsieur Brunet-Duceppe?
Oui.
Ms. Kwan?
For.
Yeas 11, nays 0.
Amendment is adopted. Ms. Kayabaga?
Thank you, Madam Chair. I would like to put the second sub-amendment. And so I move that the NDP 3 proposing to amend Clause 1 of Bill S-245 by adding text after line 14 on page 1 be amended by substituting the following for the text of the proposed subparagraph 3.3 A.01 II. Neither of these persons' parents was a citizen who had a substantial connection with Canada. And so this is this makes a change for the list of people who can meet the substantial connection requirement introduced by the NDP 1, and so NDP 3 proposed that it should be the parent or a grandparent, but this makes it so that it can only be the parent. Thank you, Madam Chair.
Ms. Kayabaga has proposed an amendment to NDP 3. Ms. Kwan?
Yeah, I'll just speak very quickly about this. My personal perspective is that we should include the grandparents so that they would be able to establish that connections test. I can go into all the reasons why that would be important, but I understand that the government does not agree with me on that. I don't like it, but I also recognize that sometimes in life there are many things that I don't like, but I just have to learn to live with it.
Ms. Rampel-Garner?
Perhaps I can ask both the officials and perhaps my colleagues opposite, just so that I'm keeping score appropriately here. The amendments that we've made so far in the list of orders, I think, so what's being proposed here would keep it consistent. Like, we haven't introduced, to date, we have not so far in the list, we have not yet introduced the concept of grandparents, correct? Okay, so is that correct? Yes?
I'm sorry, I think this is just coming up now. So you've heard the proposed sub-amendment to limit it to parents.
Okay, so perhaps through you, Chair, to my colleague, Ms. Lalonde, if could she just like run through it one more time? So I'm just not clear now with the two Liberal sub-amendments what the amendment overall actually does. Like, how does it change it substantively based on if it wasn't here at all? Like, what now that, like, what is the, after this, if this Liberal amendment passes, what is the function of the amendment as amended? Like, who would it affect? What cohort?
Ms. Lalonde?
I certainly would like the officials, but my understanding, again, is we are removing grandparents from the NDP 3 motion as a sub-amendment to remove, because if you read the NDP 3, it says parents or grandparents. What we're proposing is to take grandparents off, and certainly my colleague and the officials can share that.
Then we will come to you. Mr. Dhaliwal?
Thank you, Madam Chair. Madam Chair, then basically, if we, instead of bringing the amendment, if we just defeat the Madam Kwan's amendment, that will probably do the job anyways, isn't it true? Because the one that we passed is just the first generation. So she was trying to introduce the grandparents, and if that grandparents category doesn't go through, then it's fine. Even bringing in the sub-amendment does the same thing as bill will do as it is.
Ms. Rempel Garner?
What I would ask either... I need another coffee before we get into these technical points, I think. Okay, so what I'd like to just try to ascertain is, I understand what this amendment is doing now, and I think I understand what the motion as amended, as it currently sits, does, because it places a restriction on what has already been passed, correct? I guess what I would ask is there a more... It seems to me like we're confusing two matters in the same motion, and I know that I'm feeling negative energy vibes from the law clerk table, because whenever we confuse two matters in the same amendment, it can sometimes lead to confusion in the legislation, and I'm wondering if there's a more elegant way for us to achieve what Ms. Kayabaga had originally proposed with the first amendment, while it seems to be a consensus emerging to delete the substantive parts of the rest of this amendment. And I might look to the law clerk for advice on that as well, too, or maybe I'm misunderstanding. Because I just to be clear, what I'm saying here is I agree, and the reason why we supported the last amendment was I agree with what Ms. Kayabaga proposed to clarify what happened in the first instance. But now what I think is happening is that we are, like, amending the rest of the motion so that it kind of like doesn't do what it was originally supposed to do. So I'm just wondering if it should just all be defeated and then we put that clarification in a different way. If I'm misunderstanding, I'm happy to be corrected. I just want to know what I'm voting on the last.
Thank you, Ms. Rempel Garner, Ms. Kayabaga, and then Ms. Lalonde.
Madam Chair. NDP 3, as proposed, reads, allows both a parent or a grandparent to meet the criteria for substantial connection to Canada. And what I'm proposing as the second sub-amendment is to only make it for parent and not grandparent. So that's what we're proposing. It's a very minor change, doesn't affect the entire NDP 3, and we would like to, but this is a technical amendment, and that's what we're changing grandparent to parent, basically. That's what you're voting on.
I certainly happy to just reiterate what my colleague says. the NDP3 is needed because it talks about who can meet the substantial connection. But what we're proposing is that we do limit the substantial connection requirement as being only by parents, by person's parents, and not grandparents.
Je pense que c'est assez clair. Là,
I think it's very clear, the sub-amendment, just getting rid of the grandparents. I think the Quebecers will be in favor of this sub-amendment.
No further discussion. We will ask the clerk to take the vote. Mr. Clerk, if you can please take the vote on the sub-amendment. We are voting on the sub-amendment 2 proposed by Ms. Kayabaga.
Mr. Ali,
yes.
Mr. Dhaliwal,
Yes.
Monsieur Elkoury, Madame Kayabaga,
Oui.
Madame Lalonde,
Oui.
Mr. Kimmich,
Yes.
Mr. McGuire,
Yes.
Mr. Redekop,
Yes.
Ms. Rempel-Garner,
Yes.
Monsieur Brunel-Duceppe,
Pour.
Ms. Kwan.
Against.
Yeas 10, nays 1.
The amendment proposed by Ms. Kayabaga is adopted. Back to Ms. Kayabaga.
Thank you, Madam Chair. Now, I would like to put sub-amendment number 3. So I'd like to move that NDP 3 proposing to amend Clause 1 of Bill S-245 by adding text after line 14 on page 1 be amended by adding the following after the proposed text. 2.2, that the portion of paragraph 3.3b of the Act before subparagraph I is replaced by the following. B, if the person was born before April 17, 2009, and at any time only one of the person's parents was a citizen, and that parent was a citizen under any of the following provisions, or both of the person's parents were citizens under any of the following provisions. 2.3, subsection 3.3 of the Act is amended by striking out or at the end of the paragraph 8.2 by adding or at the end of paragraph B and by adding the following after paragraph B. C, if the person was born after April 16, 2009, and I, at any time, only one of these person's parents was a citizen and that the parent was a citizen under any of the provisions referred to in subparagraph BI to VIII, or both of the person's parents were citizens under any of those provisions, and II, at the time of their birth, neither of the person's parents was a citizen who had a substantial connection with Canada. So, Madam Chair, NDP 3 is proposing automatic citizenship by descent beyond the first generation for anyone who has a parent who meets a substantial connection to Canada. However, as written, it would exclude someone who has a Canadian parent who was born before February 15th, 1977, and even if they meet the substantial connection requirement. So we believe that this is a simple oversight, and this sub-amendment fixes the oversight and allows the parent to meet the substantial connection requirements regardless of when they were born. Thank you, Madam Chair.
Thank you, Ms. Kayabaga. So we have a sub-amendment proposed by Ms. Kayabaga. Any discussion?
You had it distributed? It was just
distributed.
Okay.
It's been distributed. It might take a couple seconds.
Okay. It's email? Is it through email? Okay. The clerk has sent an email, so it's coming to everyone. Mr. Redekop.
I just, while we're waiting for that to come and reading it, I just want to, so that everybody has the right story on what's going on here. This is very complicated, and it's hard to understand. And so if anybody questions why we're asking questions, it's because we want to make sure and get it right. We want to understand what's going on. We want to make sure that you guys are in favor of this, because ultimately it's you that have to make this work. So it's a lot of I's and things like that to understand. So just to be clear, we're not trying to slow this process down. We're trying to make sure that it's done correctly.
Mr. Brunel-Duceppe.
Je peux me permettre, Madame la...
If I can, Madam Chair. I fully agree with my colleague, Brad, because when we have a bill that is so complicated and you have sub-amendments on the floor, well, we are trying to come up with a good bill, and I find it hard to understand why these sub-amendments were not sent to all of our colleagues so that the research capacity of all political parties could have paid attention to this. I mean, if these are written, it means that they were written a while ago. I don't think that the Liberal Party wrote these down 15 minutes before the committee started. So it would have been nice on their part and the right thing to do on their part to have shared the sub-amendments beforehand, so that we could just do a deep dive into it. It's unfortunate. It's usually how we work, so it's a bit of a shame. So for the next time, maybe the Bloc Québécois will come up with complicated sub-amendments to present on the floor. I don't know.
So next we have Mr. Kimmich and then Ms. Lalonde. Mr. Kimmich.
So I'm going to ask the officials for obviously questions. I'm just following with the amendment I have here in the notes I took from when Ms. Kayabaga was speaking. So this would be, and then I want you to correct me if I'm wrong and tell me what is the correct answer, just so I understand. This is the group that, so it would be parents pre-2000, April 17, 2009, but it would also apply for the substantial connection test for those I heard 1977. Yeah. And so that's what's really confusing me. So those who are not born in Canada, I heard, who cannot prove or were not made to prove substantial connection to Canada pre-1977. So it sounds like there's like two things at play here. I think it would really help if you had an example on how this would function, because this is all over the Citizenship Act. So if you could just help us understand.
Gerard?
Thank you, Madam Chair. So as the member was mentioning, this is an amendment which is intended to provide equal access to the connection test to children born since 2009 who were impacted by the first generation limit, where only the parent is given access to demonstrate the connection test. And it's which parents, the issue for the sub-amendment is which parents will have access. And we think through a drafting issue, there may have been an oversight where it was drafted in a way that it was covering only parents born since 77. So you could have a family where you have one parent whose kid was born abroad in 1976, and they grew up in Canada, but they wouldn't have access to the connection test for their child born abroad in the second generation. And the other sibling was born in 1978, which is after the 77 dividing line. So all this amendment is looking to do is to say, regardless of when your parent was born, if your child was born abroad from 2009, you can access the connection test via your parent.
Ms. Lalonde?
Juste peut-être un commentaire.
Just a comment, maybe two comments. I think we all agree on the complexity of what's before us. I would like to thank all those who are here to help us out, to clarify things. And for my colleague, I do understand your desire to have had the documents beforehand, but we cannot bring forward a sub-amendment before the amendment is brought forward. So, as was mentioned, we cannot talk about a sub-amendment before a motion is put forward to bring forward an amendment due to confidentiality reasons. But I would like to thank all the people who are here today with us to help us understand the complexity of all this.
Mr. Redico.
So, so it appears to me that this sub-amendment actually is not really related to anything that Ms. Kwan's amendments bring forward. This is something that's an oversight in the existing legislation. That's just, since we're here, we're going to fix it. Is that the right way to understand this?
Madam Chair, that's not correct. It's related to Ms. Kwan's amendment in the sense that it's introducing a connection test that's accessible to those born abroad in the second generation and beyond. It's a mechanism that doesn't currently exist. And so, as the member mentioned, it's a minor adjustment to address a drafting issue, which is probably unintended, cutting out some parents when it was intending to be inclusive with regard to the proposed connection test for parents to meet of these children born abroad since 2009, if I can sum it up that way. Thank you.
Mr. Brunel de Sepp.
Thank you, Madam Chair. Just a question about my colleague Marie-France's comment. So there's never any discussion between parties on amendments or sub-amendments before the committee meeting? Have you never had such discussions with other parties on amendments and sub-amendments? I mean, I'm not going to push this idea any further, but I think we all have the understanding that this sometimes happens.
Ms. Rempel-Gardner.
Okay, I just want to clarify some questions that Mr. Redekop had with the officials. So, Ms. Girard, through you, Chair, to Ms. Girard, you mentioned that it was a drafting error, but it wasn't a drafting error with the bill as originally received by this committee. It was a drafting error with the amendment, correct?
Yes, with the motion, that's correct, yeah.
Okay. Are you aware of, and again, like I'm just being, I would look myself, but are you aware of any debate on this particular issue that came up when the bill was in the other place?
Oh,
Ms. Girard.
Madam Chair, since the issue was not addressed in the original form of the bill, I don't believe it was an issue that came up at that time. Thank you.
Perhaps to the law clerk, just because again, I'm trying to understand where this fits in the grander scheme of things. Would this amendment be ruled in scope of the bill had the House not passed the motion to expand the scope?
Thank you, Mr. Gardner. If I can ask the legislative clerk to clarify. Thank you, Ms. Rempel-Garner, for your question. As per the advice of the legislative clerk, it is admissible right now in the present situation. So,
okay, I guess like just to build on what Mr. Brunel de Sepp, my colleague, said, and I'm just going to state this as a blanket sort of reservation to qualify how I think I'm going to be making my mind up on how to vote on some of these amendments, just for the record. My concern is that the bill in the original form went through the Senate fairly quickly. There wasn't a lot of debate beyond this, and we I haven't seen data on the implication of some of these amendments. Like, for example, we asked, and I understand, like, this is not a slight on the department, but, you know, like, what the cohort would be that was impacted by this, if there's resourcing issues, if there's administrative issues that may come up with this, and, you know, we don't have that in front of us. And part of the reason why, you know, procedurally we try to keep clause-by-clause amendment to bills within scope is because typically the legislative process would be you would go through testimony, you would have study, you would have data to review as a legislator, and what we're being asked to do here is to, as my colleague Mr. Brunel de Sepp said, really consider substantive amendments that were beyond the scope of the initial bill considerably, like on the fly trying to listen to like sub-amendment A, B, C, D, E, and F, when this actually has significant implications for how many people can have the right to claim citizenship to this country. And, you know, I'm now sitting here going, okay, well, just really not feeling like I have the resources and tools as a legislator to consider this carefully. That just really concerns me. This is why there's procedure where we typically don't do business this way. So I think I understand what my colleagues on the governing side are trying to do. I think that they're trying to fix an amendment that was put forward by the NDP, but based on what we've just heard, that there's a drafting error in the amendment from the NDP that would potentially have been quite out of scope of the original bill. I just want to reserve that I think we could be having some significant unintended consequences here. I understand that, we're trying to fix a situation and keep it tighter, but my preference would be that we stick to the original scope of the bill as much as possible in order to make good decisions that have already been reviewed in other places, in debate in the House, in whatnot. So, I just want to qualify that when I'm voting on this, I'm trying to do as best as I can with limited data under a programming motion that I don't think was in the best interest of this bill. And I just worry I'm going to make mistakes here. And I just wish I wasn't in this situation. Thank you.
Thank you, Mr. Empel-Gardner. Mr. Kimmich.
So so again, I'm trying to understand everything. So this is, with this sub-amendment passing, this will apply only to parents, no grandparents, regardless of age of the parent and place of birth. The substantive test, the only test will be the 1,095 days, non-consecutive, as long as you can show it. For all children born after 2009, okay, good, everybody's nodding, I'm still on the right path. Parents of any age, then how many people do you estimate this could potentially? This is a question I'm going to ask often. What will be the estimate on how many people will be affected?
Thank you. That is a correct and good summary, first off. Secondly, I'd just like to reiterate that while it's difficult to estimate with any precision, it's likely benefiting thousands in the future. Those children of the first generation born abroad for whom we already receive in the range of 40 to 60,000 requests for proof of citizenship per year as a kind of a frame. It's 40 to 60,000 applications for proof of citizenship we receive yearly in the department this is for the first generation born abroad to prove their citizenship. And it's the children of those people who can benefit from this change that's under discussion and consideration. What we don't know is how many may come forward to request it in the future. That can't be estimated at this time. Thank you.
Madam Chair, the 40 to 60,000, that's annual?
Yes, that's correct. We receive in the range of 40 to 60,000 applications for proof of citizenship for the first generation born abroad who are citizens by law, and because their parent was either born in Canada or naturalized in Canada prior to their birth. Thank you.
So now I'm going to go back to the Senate testimony for S230, which is the original version of this bill, because during that testimony, there are numbers. So Alec Atfield, the Director General, Citizenship Branch, Strategic and Program Policy, IRCC, your predecessor, if I'm correct, in there had, as a result of the for the 2009 and changes and then the subsequent 2015 changes, as a result of the communications there, in the range of 17,500 people became Canadian citizens or regained their citizenship as a result of that. There was extensive and sustained communication at that time. With the 2015 amendments, another 600 cases were identified and became Canadians as a result of the changes in the law, and that the communication resulted from that. The 40 to 60,000, this is minus, annually now that request, for proof of citizenship, so the certificate or the number or the microfiches like we talked about last time, to get their number. Those 17.5 at some point were requested from the department. Are they included in that, or is that separate? And if the department, after the fact, was able to estimate for the 2009 changes and 2015 changes, why can't the department provide a stronger estimate now?
Yes, thank you, Madam Chair, for the question. So those are also numbers that I've mentioned in my previous testimony. The 17,000 some from 2009, plus the lost Canadians remedied in 2015, and in fact, our updated numbers are in the range of just under 20,000 who came forward to request a proof of citizenship. The difference is those are actuals. Those are persons who were remedied by the law who actually came forward and applied since those legislative changes were passed, and we continually update the numbers for these purposes to provide an up-to-date testimony at committee. So those lost Canadians who came forward in those numbers that the member referenced would be up to the first generation born abroad. And so the descendants of those people, should the committee and should Parliament legislate and pass this bill, would also have access to the connection test, but they would be included in the rough estimate that I've alluded to in the thousands, though difficult to know how many came forward. And because those are actuals, as I mentioned, that you were provided at that time, and that I mentioned actually during I think my first appearance before this committee. Thank you.
Just so I make sure, because back then, Catherine Scott, Associate Assistant Deputy Minister, Strategic and Program Policy, IRCC. I made a note here because I went through all the testimony again. Said that legislative amendments gave citizenship back to almost all lost Canadians. If this passes, this sub-amendment and amendment, right now, will this include most of those lost Canadians that were not included in the 2009 Citizenship Act change and the subsequent 2015 changes as well? So I'm wondering, is this amendment, the sub-amendments, a large group of people who would be considered lost Canadians who will be included, or is this a smaller group? Is this more like 2009 or more like 2015?
Madam Chair, thank you for the question. I think in summary, that the correct summary, that the vast majority of lost Canadians were remedied in 2009. The caveat being that up to only the first generation born abroad were included in those previous remedies for consistency with the first generation limit. And so as we've mentioned, this bill was initially dealing with a small cohort who were left out, the Section 8s, because they were second generation born abroad. And so the topic of this particular amendment and sub-amendment is about others who see themselves as lost Canadians because there's not a direct avenue or mechanism to access citizenship for the second generation born abroad, the larger cohort estimated to be in the thousands, where the parent has a strong connection to Canada and can demonstrate that they have been in Canada for at least 3 years. Thank you.
You raised your hand. You were on my speaking list.
Thank you.
Lost your thought.
Well,
My speaking list.
Well, Madam Chair, I wanted to originally comment on the question that Mrs. Rempel had asked, but based off of Mr. Kimmich's questions, it sounds like it makes sense. And what we're trying to do is to bring an amendment to NDP 3. And I think the questions you asked brings me to believe that you understand what we're trying to do here. So I don't want to add too much comments on this because the mic doesn't want me to speak either. So.
Thank you. Any further questions? No? So we will have to go for a vote on sub-amendment proposed by Ms. Kayabaga. I will ask the clerk to please take the vote. So we are voting on the sub-amendment by Ms. Kayabaga.
Mr. Ali.
In favor?
Mr. Dhaliwal.
Support.
Monsieur El-Khoury. Madame Kayabaga.
Pour.
Madame Lalonde.
Pour.
Mr. Kimmich.
Yes.
Mr. McGuire.
Yes.
Mr. Redekop.
Yes.
Ms. Rempel-Garner.
Yes.
Mr. Brunel-Duceppe.
Oui.
Ms. Kwan.
Yes.
Yeas 11, nays 0.
Adopted. So we have NDP 3 as amended. Ms. Rempel-Garner?
Could somebody read it out as amended?
Okay. We will have the... Everyone is taking a deep breath.
Or could we see a copy of it?
Okay. So the legislative clerk would need few minutes. We can suspend for few minutes so that we can have NDP 3 as amended. Ms. Kwan?
I wonder if this would suffice, instead of reading the amendment, to just actually summarize what it does, because we could, but it'll be citing, section I and F and this and that, and that would be hard to follow in any event. So
We can have him read it, and then if there is any explanation needed, we can go to that. Ms. Rempel-Garner?
I love all of my colleagues, and I know we work in the spirit of nonpartisanship, but this is significant legislation, and I would actually like to have the opportunity to review what it is we're voting on, given the change in the substantive motion, just because it's so technical and there's been so many changes to it. So that would be my preference. Thank you.
Suspend the meeting for a few minutes so that we can have the amendment as amended, and then we can go for a vote. Thank you. we have the Ledge Clerk ready, as requested by the members, to read the amendment as amended. Over to the Ledge Clerk. Thank you.
Thank you, Madam Chair. Hopefully the attempt is successful. So that the amendment would read, once amended 3 times over, like this: that Bill S-245 in Clause 1 be amended by adding after line 14 on page 1 the following. 2.1, paragraph 33A of the Act is replaced by the following. A, if the person was born before April 17, 2009, and at the time of his or her birth, only one of the person's parents was a citizen, and that parent was a citizen under paragraph 1B, C, E, G, G1, H, O, P, Q, or R, or both parents, or both the person's parents were citizens under any of those paragraphs. A, 0.01, if the person was born after April 16, 2009, and at the time of his or her birth. I, only one of the person's parents was a citizen, and that parent was a citizen under paragraph 1B, C1, E, G, G1, H, O, P, Q, or R, or both of the person's parents were citizens under any of those paragraphs. And 2, II, neither of the person's parents was a citizen who had a substantial connection with Canada. Capitalize, A, had a substantial connection with Canada, or B, had a parent who was a citizen with a substantial connection with Canada. And then 2.2, the portion of paragraph 3.3b of the Act before subparagraph I is replaced by the following. B, if the person was born before April 17, 2009, and at that time only one of the person's parents was a citizen, and that parent was a citizen under any of the following provisions, or both of the person's parents were citizens under any of the following provisions. 2.3, subsection 3.3 of the Act is amended by striking out or at the end of paragraph.
Point of order. I don't think that the information that the clerk is reading right now matches with the sub-amendments that we have made. So, yeah, can we review that again, Madam Chair? Thank you.
Okay. We will have to suspend the meeting so that we can incorporate and make sure that everything is there. So the meeting is suspended. Clerk, so to read NDP 3 as amended.
Thank you, Madam Chair. My apologies for that. I misread the second sub-amendment. Should I start from the the top, or?
Yes, please. Yes.
Okay. It is water, I can confirm. So that bill S245 in clause 1 be amended by adding after line 14 on page 1 the following. 2.1 paragraph 33A of the Act is replaced by the following. A, if the person was born before April 17, 2009, and at the time of his or her birth, only one of the person's parents was a citizen, and that parent was a citizen under paragraph 1B, C1, E, G, G1, H, O, P, Q, or R, or both of the person's parents were citizens under any of those paragraphs. A01, if the person was born after April 17, 2009, and at the time of his or her birth, that is, only one of the person's parents was a citizen under that parent, and that parent was a citizen under paragraph 1B, C1, E, G, G1, H, O, P, Q, or R, or both of the person's parents were citizens under any of those provisions, and those paragraphs, and II, neither of the person's parents was a citizen who had a substantial connection with Canada. Two, the portion of paragraph 33B of the Act before subparagraph I is replaced by the following. B, if the person was born before April 17, 2009, and at that time only one of the person's parents was a citizen, and that parent was a citizen under any of the following provisions, or both of the person's parents were citizens under any of the following provisions. 2.3, subsection 3.3 of the Act is amended by striking out or at the end of paragraph A2, by adding or at the end of paragraph B, and by adding the following after paragraph B. C, if the person was born after April 16, 2009, and I, at any time, only one of the person's parents was a citizen, and that parent was a citizen under any of the provisions referred to in subparagraph BI to 8 Roman numerals, or both of the person's parents were citizens under any of those provisions, and II, at the time of their birth, neither of the person's parents was a citizen who had a substantial connection with Canada.
Thank you. Is everyone clear on that? Mr. Maguire.
Thank you, Madam Chair. And if I could, to the clerk, thank you for that. I don't have it all written down here, but as I was trying to follow this, just to go back to the 2.1, the A.01, the first one, I believe there was difference in dates there. If the person was born, I believe you said after April 17th, the paper I've got is the 16th? 16th it would be? Because I think that's clear with the section C part that was April 16th as well. Okay. Yeah.
And the B part, the A01. Oh, sorry.
Oh. Yeah, I'm not. Wasn't picking you up there.
Put it down and then let him talk. Like this.
Oh, okay, there you go. Okay, go ahead now.
Yeah. So yes, in paragraph A, in the NDP 3 amendment, first line, if the person was born before April 17, 2009.
Oh, before.
And then A01, if the person was born after April 16, 2009.
Mm-hmm, mm-hmm. So I just want to ask our colleagues across the way, now that those amendments are all there. Oh,
yeah.
Sorry.
If I can recognize
yeah,
and
thank
then,
you. Thank you for the floor. Does this do what you want it to do? Can you just describe that to me, as I don't have it all written down here?
Can you please repeat?
Well, I'm just asking what it does. Now that we've got it all out and it's been read to us, does this do what you wanted it to do? And if you could just describe what that was.
Sorry, just 1 second before I go to the next person. Are you asking in regards to explanation on the sub-amendments? Okay.
That's all I was looking for.
On this,
Just clarity.
On this amendment as amended?
Yeah.
The whole thing? Okay.
Yeah.
Yes. So, Ms. Rempel-Gardner?
Okay, I actually think this is a good question, but I'm going to put it a different way. Can I ask my colleague, Ms. Lalonde, as amended, what is her intent for it to do? And I asked that, so as amended, what is the actual mechanism it's trying to do? And I think it's important to get this on the record because sometimes when there's legal interpretation matters, they do look back towards occasionally committee testimony. And I just want to get it on the record what the intent is as amended.
Thank you very much to my colleague, and I'll be very brief because I would love to think that we could end S245 today. So NDP 3 now with those amendments now describes who can meet the connection test, and the person who can meet the connection test is a parent born anytime as long as their second generation child is born after April 16, 2009.
Okay. Thank you. And then to the officials, based on your understanding of the amendment as amended, does it do what Ms. Lalonde said it was going to do, or does it have any, is there any ambiguity in the intent or potential ambiguity that we should be rectifying with further sub-amendments?
Ms. Girard?
Thank you. No issues with the motion is sub-amended. It's clear, and it's drafted in a way, as read by the clerk, that will enable the implementation as intended and as outlined by the member. Thank you.
Mr. Kimmich?
Yeah, as much as I like the amendments that have, the sub-amendments that have been done to the amendment, I just want to be clear that because the substantial connection test isn't as substantive as I would like it, I still intend to vote against the amendment, despite liking all the sub-amendments.
Okay, no further questions. So we have NDP 3 as amended. So we will vote on NDP 3 as amended. Okay, everyone clear? Mr. Clerk, if you can please take the vote.
Mr. Ali?
Yes.
Mr. Dhaliwal?
Vote.
Mr. El Khoury? Madame Kayabaga? Madame Lalonde?
Oui.
Mr. Kimmich?
No.
Mr. McGuire?
No.
Mr. Redikoff?
No.
Ms. Rempel-Garner?
No.
Ms. Sabrina Giuseppe?
Pour.
Ms. Kwan?
Yes.
Yeas 7, nays 4.
Adopted. So NDP...
Point of privilege.
Mr. Kimmich?
Point of privilege. So, Madam Chair, I've been waiting for this just to confirm that information I had received from an outside party was correct. So this is a point of privilege, because I believe that some of the amendments of this committee were shared with a stakeholder, including sub-amendments. So, to the point that my colleague from the bloc was making, that people have been talking to outside groups, including 2 political parties here. And I have an email that I'm going to read, and I was also so kind to get a French translation for my friend Alexi from the bloc. So in this email that I received April 28, 2023, so I'm going to read the email, then I'm going to go into the point of privilege and what I believe the role of the chair is. This is what I was told. So following up on our conversations in committee, there are 2 sets of amendments to Bill S245 related to the after first generation exceptions in the Citizenship Act. And here's where my concerns begin. NDP-1, NDP-3, NDP-5, NDP-8, NDP-12, G2, G6, G7, G8, and G9. Then it continues on from our perspective, and this is from the stakeholder group, and I don't blame the stakeholder. This is not their fault. This is something that happened here at committee between parliamentarians, of which I was not included, and thankfully there are no CPC amendments affected by this. From our perspective, the NDP amendments best address the issue of family separation / lost mobility for Canadians who work abroad because the connection test can be met by parent or grandparent that has a threshold that Canadians can meet naturally. One big problem with existing law is that it treats citizens so differently that nobody really understands it. So this last point is very important. It goes on, the Liberal amendment have the advantage of a grant that can be met at any point in time. If you miss the residency requirement before you have children, you can make it up, but the test is one that a great many people will miss, even if they stay connected in Canada. And here's a sentence in the next paragraph that's the most important to me, because this is exactly what's happened here on NDP amendment number 3, which is, I believe, a breach of the privileges of the committee. What I have heard about the Liberal NDP compromise is that they will offer sub-amendments that have just happened to the NDP amendments to increase the connection test to 1095 days, which is the sub-amendment made the reference back to the substantial connection test, only for parents. We just removed grandparents, and by right versus grant. And I asked the officials whether this was by right versus by grant. The stakeholder group then goes into the details describing their preference, Madam Chair. So when I went back to Bosque and Gagnon, in 1062, it talks about notices of motions normally remain confidential until they are moved during a meeting, although the sponsoring member may choose to make it public prior to doing so. So like this would mean that any member controls their amendments, or the government side and opposition side will control amendments. We're allowed to give those out, which I'm entirely okay what people do. It continues in Bosque and Gagnon, page 1005, where there is sufficient time, if the committee agrees, the package can be circulated in advance of the clause-by-clause consideration meeting, ensuring that all members of the committee may see the amendments that their colleagues wish to make to the bill, that's the enumeration of the bills that we have. So those amendments can be shared amongst ourselves as parties meet confidentially. Everybody's perked up, so I'm glad I've got everybody's attention. We can meet, we get the numbering of all of our amendments. It just makes it easier to work out which amendments do we like, which amendments we don't like amongst parliamentarians on this committee. That's fine. So now these practices combined are such that the usual practice in committees of the House is that notices of amendments are treated as confidential once submitted to the clerk of the committee until the sponsoring member moves it during clause-by-clause consideration of the bill. Now, I have an example of what happened in another committee because I think it's very relevant to what's happened here. So now occasionally exceptions are made by committees, not individual members. So this is the example I have. Last fall, there was a debate on Parliament Hill about the Liberal government's overreach with amendments G4 and G46 to Bill C21, which is the firearms confiscation bill that the government has before the Public Safety Committee. It's still before the Public Safety Committee. Now, that committee, while debating Amendment G4, had also agreed to make public Amendment G46. We have no such agreement here that I understand. But I think reading from this email, it's indicative that a person knew the numbering of our amendments and knew what sub-amendments were going to be made at committee at some point. I didn't know about any of this, and I believe that's a breach of privileges of the committee. Now, they agreed to that, and ahead of it being moved at the appropriate stage of clause-by-clause consideration, that agreement can be found. It's recorded at the beginning of the Public Safety Committee's minutes for November 24, 2022, so if the clerks or legislative clerks want to check, or the extra legislative clerk, if they want to go check, it's there. Now, again, that said, it's acknowledged and common practice for members to engage with stakeholders in policy development, which could extend to developing those policies in the expression of legislation, including amendments to bills. It's not, however, appropriate to take the amendments which have been filed with the clerk, especially other parties' amendments, and share them with stakeholders or the public at large for comment, right? So it's a protected document to the committee. Now, the approach of the Public Safety Committee on releasing Amendment G46 to Bill C21, that shows, I think, the correct method of proceeding, the correct way of doing it. This stakeholder group did not have the right to know which amendments were which or what sub-amendments would be moved, especially because they knew the strategy of when they would be moved. So based on the communications I've received, we know that we had, that he had possession of the committee's amendment package and not merely draft text yet to be finalized and filed. He cited amendments by the reference numbers, which are assigned to them, again, like I said, by the clerk of the committee. There's no other way for him to know which ones are NDP 1, 2, 3, 4, and the enumeration of which ones were in there. So it kind of makes me glad that the Conservatives didn't submit any amendments, despite, Madam Chair, I had moved an amendment when we were going into this to give us extra time to submit them. I'm glad I didn't do that now because I don't know if they'd be made public or given to this stakeholder group. Now, because the draft amendment package has been shared with members of the public, a possible breach of privilege has occurred, and the committee must report the matter to the House for appropriate consideration. And I have the committee's chair role from the online privileges and immunities part. So it says here that unlike the speaker, the chair of a committee does not have the power to censure, disorder, or decide questions of privilege. Should a member wish to raise a question of privilege in committee, or should some event occur in committee which appears to be a breach of privilege or contempt, the chair of the committee will recognize the member and hear the question of privilege, or in the case of some incidents, suggest that a committee deal with the matter. Now, it says the chair, however, has no authority to rule that a breach of privilege or contempt has occurred. The role of the chair in such instances is to determine whether the matter raised does in fact touch on privilege, and it's not a point of order, a grievance, or a matter of debate. If the chair is of the opinion that the member's interjection deals with a point of order, a grievance, or a matter of debate, or that the incident is within the powers of the committee to deal with, then the chair will rule accordingly, giving reasons, and the committee cannot then consider the matter further as a question of privilege. Should a member disagree with the chair's decision, then he can appeal to the committee, which can sustain or overturn the chair's decision. I have the motion already written out, Madam Chair, if you find that there was a breach of privilege. So I have it here already pre-written. I can give you a copy if you want to consider that. I also have the email from the stakeholder who gave it to me. So, Madam Chair, I'm more than happy to give it to you so that you can take a look at it. And I think you will find it here. It's egregious. It is a violation, I believe, of the privileges, my privileges as a member, but those of my colleagues and those of us who are not privy to any of these conversations. Amendments are supposed to be confidential to the committee. We can share our own, and I know that's a practice that's regularly, but I have here sentences that talk about sub-amendments that were just done in NDP 3. So I believe there was a breach of privileges of the committee and my privileges as a member, because I was not party to any of this, and there is an outside member of the public who knew what the sub-amendment strategy was of certain members of this committee. Thank you, Madam Chair.
Thank you, Ms. Lalonde, and then Ms. Rempel-Gardner.
Thank you, Madam Chair. I am very upset, and I'll say very upset to hear that the amendments package was shared with anyone outside of this committee. While I can say that I have had conversation with all members about potential amendments and sub-amendments, I have never given these details to any stakeholders. The conversation had that, between the member of parliamentary is, of course, I think, a normal, and I think my colleague has made reference to this as a process. However, it is unacceptable that anyone should share any details, especially in writing, with stakeholders.
Thank you. Ms. Rempel-Gardner and then Mr. El-Khoury. Ms. Rempel-Gardner.
Thank you. I appreciate my colleague, Ms. Lalonde's comments just on this point of privilege. I actually didn't know my colleague was going to raise this today. We are going through very complicated technical amendments that will make, I've heard one analogy, I won't take credit for it. The Citizenship Act in some ways is more complicated than the Income Tax Act. And we're sitting here trying to make amendments without a lot of data that could impact operations. I'm just taking it on good faith. The information that I'm receiving is right, and this is not how the legislative process is supposed to work. However, if I have been, as a member of this committee, not afforded the same opportunity to review legislations that a member of the public has been given in a breach of privilege, that's a big deal. And it actually goes against the spirit of what we're supposed to be doing here. And I hope that you find, Chair, in favor of my colleague's point, building on the comments of Ms. Lalonde and my colleague. I want to proceed in good faith on this bill. I think that at its heart, it's an important issue that is meritorious and worthy of cross-partisan agreement. But this is actually a breach of privilege. The other question I have is this in violation of the Lobbying Act? Who was lobbying? What's going on here? How is this influence being put forward? This is anybody who's watching this committee today is now going to question the process that was undertook here. It's highly problematic. I take no pleasure in this. I do think, though, that to protect the integrity of the committee, Chair, I would implore you to find in favor. I think my colleague has outlined this. And just also to acknowledge my colleague earlier, Mr. Bernal Ducep's comment. He was not afforded the opportunity to review these amendments as we were. Now we find out that there's a member of the public who did, and that's just wrong. Thank you.
Thank you, Mr. Rampal-Garner. Mr. Al-Khouri?
Yes. According to me, it's categorically it's unacceptable. Acceptable. But through you, Madam Chair, is it possible to know which stakeholder?
If you wish.
Can you read it? Read this.
But I gave it to the chair, the direct email. No, yeah, it's my parliamentary email, so yes, you can use it.
So it is from Citizens Right. It's the organization Citizens Right. Randall Emery. Citizens Right. Yeah, that's what it is. Okay, so you. Okay, Mr. Reddycop and then Ms. Kwan.
Thank you, Madam Chair. I'll be very brief. Appreciate the comments from everybody so far. I just wanted to remind everybody that this is exactly what Mr. Bernal Ducep said earlier on about, not having access to things and not being able to study things ahead of time, and then, here we are. So it's almost a little bit ironic. But anyway, that's the whole gist of this, and I won't prolong this unnecessarily.
Ms. Kwan.
Thank you very much, Madam Chair. I also put myself on the record here to say that in the development of proposed amendments, certainly consulted with various stakeholders and including conversations with the Ledge Council on proposed amendments. However, with respect to amendments from that was submitted to the clerk afterwards, those documentations were definitely not released from my office.
Thank you. Any other?
From me, I should say very specifically, just in case if people are wondering.
Anyone else wants to speak to it? Okay. Thank you. I will have to suspend the meeting to consult with the clerk. And so I'll suspend the meeting for a few minutes and then come back. Thank you. I need more clarity and some more information on that before I make a decision. So I hope members will agree with that, that I want to make a right decision based on the things which have been raised by Mr. Kimmich. So is it all right that we adjourn the meeting today and start with this on Monday?
Yes. Makes sense. Perfect.
Okay? Okay. So thanks a lot for your cooperation.
Agreed.
Thank you. I will adjourn the meeting and see you on Monday. Thank you.
Thank you.
Thank you.